I will call our final panel for today. This panel will be discussing the history of IGRA. Mr. Frank Ducheneau, DNR Consulting, Dean Catherine Rand, University of North Dakota School of Law. Please come forward. Welcome. We will begin with Mr. Ducheneau.
Thank you, Madam Chair. Excuse me. I'd like to thank you and the Commission and Joe for getting me out of the 55-degree weather in Montana down here to San Diego and El Cajon. I appreciate the opportunity to be here to talk with the Commission about Class 2. I just, for the record, say that my wife is a member of the Gaming Commission for the Salish Kootenai tribe of Chairman Steele's, so I know a little bit about it just secondhand. I'm sorry. I have no prepared statement. I'll speak from some notes. I did provide Joe with a copy of a thing I did on the legislative history of IGRA, and it's about 52 pages, and I don't know whether, so I submit it for the record for whatever it's worth. I wanted to talk a little bit today, not just in terms of the legislative history of IGRA on Class 2 and the intent of Congress, but a little bit about the National Indian Gaming Commission. I know you've heard a lot about it already today, but I have spent a good part of my retirement years fighting with the Commission and Phil Hogan, and they're overstepping, in my mind, of the bounds of their authority under IGRA. So I want to comment a little bit on that too before we're through here today. You have heard the term tribal sovereignty mentioned here throughout the day. I have, as I indicated, talked to a lot of tribes and people involved in Indian gaming over the years, and I try to begin my comments with tribal sovereignty, because without tribal sovereignty, we wouldn't be here today doing what we're doing. We wouldn't be sitting in this building. We wouldn't be discussing our problems with federal regulatory agencies on Indian gaming, because there would be no Indian gaming. Tribal sovereignty is the beginning of an Indian tribe, and it's the end of an Indian tribe. I think it's important for tribal leaders to understand, if they do not, that they have a responsibility to pass on to their children and grandchildren, great-grandchildren, as they say in our world, the seventh generation, the tribe with their sovereignty as much as possible intact. That's the responsibility of tribal leadership. A lot of people, your people and my people and other people, Indian people, have fought long and hard over the years and lost in terms of the rights of Indian tribes. But they fought. They didn't stand by, they didn't roll over, they fought. And if they lost fighting a good fight. As some of you may know, mustering as much modesty as I can, am in large part responsible for the language of IGRA. And in a way, I kind of feel a parentage for IGRA, as bad as it may be in certain respects. And I am sometimes very disturbed to have seen tribal leaders seemingly to willingly accept the overstepping by the Commission into tribal sovereignty and eroding tribal sovereignty. And I hope very much that this kind of forum that the Sycuan tribe is providing is some clear indication that they understand that this is their responsibility. Because behind you stand the tribal leaders, Danny Tucker and others who have this responsibility, and for that part have done very well in protecting it. Why are we here on Class 2? Well, as I will get into, and as Catherine will get into later, in one respect, Class 2 is important to Indian tribes. When we were doing IGRA, it was important because that's all there was when it started out. Some of you may remember the Barona Ranch case. This was one of the things that started it for me, working with the House Committee, was the finding that Indian tribes had a right to game free of state regulations under certain conditions. There you were dealing with Class 2 gaming. There was no such thing as Class 2 at that time, but you were dealing with bingo and card parlors and the like. So the first Seminole case, a similar kind of thing, involving high-stakes bingo. Even the Cabazon case that came along much later dealt with what we now know as Class 2. So Class 2 was important in terms of getting IGRA started, in terms of our deciding that something needed to be done in the area of legislation. As we got into IGRA, as we got into the legislation, that's really all we were dealing with, because that's all that the tribes were dealing with, primarily high-stakes bingo, and the legislation that was introduced in the 98th and 99th Congress dealt primarily with the thought that we were going to be dealing with bingo. But the rationale in the Barona case and the Seminole case, later the Cabazon case, really wasn't restricting itself to any form of gaming. It was simply saying that where a state permitted any form of gaming, an Indian tribe in that state had the right to do it free of state regulation. And very slowly, some of the tribes, I remember one in Michigan, or at least an Indian guy in Michigan, began to look at casino gaming, slots and the like. And as the prospect finally dawned on our opponents that there was a real possibility that Indian tribes might be running casinos, the opposition in the Congress shifted away from bingo toward this real specter of Class 3 gaming, casinos, slots, craps, roulette, blackjack. There was a real fear on the part of our opponents that this was coming down the line. So there was a shift away from Class 2 in terms of the opposition. And I was just mentioning to someone here a minute ago that this shift of the opposition toward Class 3 kind of left Class 2 legislatively in the backwater. And there's some thought that we were not very explicit in IGRA about what we intended with respect to the regulation of IGRA. I don't think we were ultimately, but clearly as we got more opposition for casino gaming, our own attention drifted away from Class 2. But the major reason we're here today talking about Class 2 in my mind is because of the second Seminole decision, and Mr. Foreman will know this one very well. When we did the Class 3 provision in IGRA, we had to compromise. We were facing some very strong political opposition, a good part of it coming out of California with Mr. Coelho and the horse racing and dog racing industry, and we had to make compromises, unfortunately. And one of those was that we had to agree that Class 3 gaming would be illegal on Indian reservations unless conducted pursuant to a compact entered into between the tribe and the state. That went into the mix. We knew, the staff people who worked on it, that if we had stopped there, the states could simply walk away from the tribes. So we needed to reestablish the balance of power that Cabazon gave us. So we included in IGRA a provision authorizing the tribes to sue states who failed to bargain or who did not bargain in good faith for a compact. And that evened it back out again. Unfortunately, after the passage of IGRA and after a passage of about 4 or 5 years, the state of Florida raised the 11th Amendment and asserted that Congress had no constitutional power to subject states to suits by Indian tribes. And the Supreme Court agreed in the Seminole decision. That immediately put the states in the driver's seat on Class 3 gaming. And the tribes of California are experiencing the result of that. Tribes across the country are experiencing the result of that decision, which simply means that the states do not have to bargain with the tribes anymore. And I know you guys dealt with it through a referendum, but in general, the Seminole decision destroyed the compromise we made and subjected the tribes to the coercion by the states, so to the point where many states in their compacts have hijacked the revenue of Indian tribes on Class 3 gaming. If you'll read IGRA very carefully, you will see that we provided that the states would have no power to impose taxes on the revenue, gaming revenue of Indian tribes, and that any attempt by a state to do so in a compact would be ipso facto bad faith bargaining. Yet that's exactly what these so-called revenue sharing provisions are. They're taxes on Indian tribes in violation of IGRA, and the states go free with violating the federal law. So for many tribes, and you heard Chairman Steele speak to the Salish Kootenai situation, for many tribes who cannot get a compact because of the Seminole case, or are presented with the prospects of compacts that are unpalatable from the standpoint of tribal sovereignty, Class 2 gaming remains an opportunity for the tribes to even out the playing field again. And we understand there are Class 2 machines on the floor out here. Salish Kootenai, all Class 2s. I think you heard J.R. Matthews talk about the Quapaw Class 2 situation where Indian tribes were able to use Class 2 again. It's now back to the 4 where it was in the backwater. So Class 2 is very important now. It has become so again. But we're faced with some real problems with Class 2, not the least of which is Mr. Hogan and the Commission. When we did Class 2 and classified Indian gaming into the 3 classes, we defined bingo, and you'll see it in the Act. There are three criteria which, if met, constitute bingo. It doesn't matter what the state law of California is with respect to the definition of bingo. It doesn't matter what the common understanding of bingo is. All that matters with respect to Indian tribes and IGRA is what the definition of bingo is in the Act. And the federal courts have essentially said that. Bingo, in terms of IGRA, is what IGRA says it is. It is those 3 things. Yet you have the Commission and recent proposals attempting to say that Indian bingo is something beyond those 3 criteria, that it has to have other elements to it, or it constitutes a Class 3 game. One of those provisions that they seized upon in IGRA is the term facsimile. In fact, we put the term facsimile into the Act after some pressure from the other side. There was a concern at that time that Class 3 slot machines would attempt to be offered using the symbols of Class 2 gaming, so that you would have a Class 3 machine, which was a slot machine, using the symbols of bingo. So we said, we're not going to permit that. That if there's an attempt to offer a slot machine using the facsimiles of bingo or some Class 2 machine, it would remain a Class 3 machine, a slot machine. But as I've said here today, a slot machine is very easy to understand. A slot machine is a gambler gambling against that machine. I don't know the whole technology, but a random number generator in the machine, and it's just the machine and that person. Bingo, as I already indicated, is something quite different. It's something that IGRA says constitutes those three elements. And the exact reverse has happened. Bingo machines, bingo game is being offered using the symbols of slot machines. So you see, I don't know all of the symbols, but you can see on some of the bingo machines, they put the bingo thing over here, but the rest of it is all slot machine-like. It's a marketing strategy. But the fact of the matter is, it remains a bingo machine. But Phil Hogan stood the term facsimile on his head and said, even if it maintains the essential characteristics of bingo, if it uses facsimiles, it's a facsimile, and thereby it's a Class 3 machine, and you need a compact. That's much bull. And I would hope that the tribes would stand up very strongly against that. Another issue, and I'm taking a little long, but I'll be done in a minute, is the application of technology. When we were doing IGRA, this was in 1983, 84, 85, 86, 87, 88. There had not been the explosion of the internet. The internet was in its infancy. Computers, computers were not in their infancy, but they were not what they are today. The technology, in short, was very rudimentary in terms of what we have today. There were bingo blowers, there were TV monitors, card minders, some other things. But we understood, and I will say it for the record, those staff people who worked on IGRA understood that technology advances in this country almost exponentially, that it just goes like that. And we intended that Indian tribes have, and you'll read it in the Senate committee report on S555, have maximum flexibility to use technology to enhance Class 2 gaming. I don't know what it is about that term that Hogan and the commission did not understand. Maximum means the most that you can have. And we did not intend to limit that to what was in existence in 1983 or 88. We intended that Indian tribes have the ability to use advancing technology to the maximum extent possible to enhance their offering of Class 2 gaming. And that's what it's all about. That's what this whole fight with the commission is all about. Their refusal to accept that. And I would hope, well, I'll get into that as I finish here. One last thing I want to talk about before concluding is the intent of Congress on tribal sovereignty, tribal self-government, and tribal self-regulation. We classified gaming into the three classes. Class 1, we said, will be social, ceremonial, and will be left solely to the regulation of the Indian tribe. We were very clear, solely to the regulation of Indian tribe. We said Class 2 shall be bingo and the other things, and shall be within the regulation of the Indian tribe, subject to the oversight, responsibilities, and authority of the commission. We said Class 3 would be regulated pursuant to a compact between the tribe and the state. That's the way we put it. The commission came along and established the most detailed regulations you could imagine for Class 3, Class 3 mix, when the Act told them that the regulation was to be as provided in a compact. But they decided for some reason that a little throwaway piece of the Act saying they had a right to promulgate regulations gave them right to ride roughshod over tribal sovereignty. I railed against that for a number of years, urging the tribes to stand up against it. And they did not, until one tribe had the guts to do it, Colorado River Indian tribe, finally stood up and took them to court and won. The court was very clear. I don't think the court could have been more clear about Congress's action in IGRA. We did not give the commission that authority. It's not there in the plain language of the statute. There's no authority for the commission to impose those kinds of detailed regulations. So that's kind of taken care of. Now, the commission has embarked upon an attempt to impose those kinds of detailed regulations on Class II gaming. If you look at the legislative intent, if you look at the language of the debate, if you look at the committee report, you will see that we did as much as we could to preserve the right of tribal sovereignty, the right of tribal self-government, and it was clearly our intent with respect to Class II that the tribes have the primary, and that's the language that's used, the primary authority to regulate Class II. Primary authority to regulate Class II. Have any of you looked at their Class II mix? They're the same kinds of mix they were attempting to apply to Class III. They're that thick, about 2 inches thick, and they regulate almost every aspect of Class II gaming. And how does that comport with the legislative intent and the legislative history of IGRA that tribes have the primary responsibility to regulate Class II? They leave no room for Indian tribes to regulate Class II. It's my opinion that the mix is illegal for 2 as they were for 3. And I'd hope at some point that the Indian tribes would stand up and take that position. Some tribes have said, well, we might lose. I was telling the professor here, you already lost if you accept that the commission has the power to do that. You already lost. And if you litigate it and lose, you lose nothing except time and money. But maybe it will be like Crit, and the court will say, Congress did not give the commission the power to impose those kinds of detailed regulations on Indian Class II gaming. I think that concludes my comments.
Thank you, Mr. Ducheneau. Dean Rand?
Thank you. My name is Catherine Rand. I am the Dean and also Floyd B. Sperry Professor at the University of North Dakota School of Law. I'm also the co-director of the Institute for the Study of Tribal Gaming Law and Policy. Thank you to the Commission for the opportunity to provide you with information on this important topic and to participate in this historic hearing. I hope that the Commission will bear with me. My testimony today is taken from the written statement that I submitted. As a legal academic, I think that one of the things that I can contribute to today's hearing and what comes after today is sort of a 50,000-foot view, a framework to provide some additional structure and context for the other testimony that the Commission has and will hear. My testimony today, of course, concerns Class II gaming under IGRA, particularly Congress's intent in defining Class II gaming. And my testimony will close with recommendations for 3 overarching policy goals to guide tribal regulation of Class II gaming. As I mentioned, I co-direct the Institute for the Study of Tribal Gaming Law and Policy at the University of North Dakota, along with Dr. Stephen Andrew Light. My testimony today is informed by our research and scholarship in the area of Indian gaming over more than a dozen years, including our 3 books on tribal gaming. I'd like to start with the role of Indian bingo and tribal economic development. As the Commission knows, the familiar game of bingo is an American pastime. Back in 1976, when the U.S. Commission on the Review of the National Policy Toward Gambling released its final report on gambling in America, bingo was legal in 34 states and was already a billion-dollar business in the U.S. In 1979, when the Seminole tribe opened its high-stakes bingo hall, dozens of other tribes followed suit. The growth in Indian gaming, and particularly in Indian bingo during the 1980s, and the accompanying tensions between state power and tribal sovereignty attracted Congress's attention as early as 1985, when it held hearings on tribal gaming. By 1988, as Congress debated over the bill that would become IGRA, 45 states had legalized bingo, and Indian bingo was a term of common parlance. As the Senate report accompanying IGRA noted, since the Seminole tribe opened its game in 1979 and over 100 bingo games have been started on Indian lands in states where bingo is otherwise legal. These games at the time generate more than $100 million in annual revenue to the tribes, enabling them like lotteries and other games have done for state and local governments, to provide a wider range of government services to tribal citizens and reservation residents than would otherwise have been possible. As the Commission well knows, Congress's enactment of IGRA was spurred by the Supreme Court's decision in the Cabazon case. And that case, of course, involved the high-stakes bingo games that were conducted by the Cabazon and Morongo bands on their reservations. In its decision, the Supreme Court considered the role of the tribe's gaming enterprises as tools of economic development, noting the U.S. Department of Interior's position on tribal gaming enterprises, particularly tribal bingo operations, as supported by current federal Indian policy. In fact, the Cabazon court quoted an affidavit submitted by the Bureau of Indian Affairs, which stated, "It is the department's position that tribal bingo enterprises are an appropriate means by which tribes can further their economic self-sufficiency, the economic development of reservations, and tribal self-determination." The federal government's overriding goal of encouraging tribal self-sufficiency and economic development, of course, mirrored the goals of the Cabazon Band and Morongo Band in conducting competitive and tribally controlled bingo operations. The court's decision in Cabazon placed pressure on Congress to enact a regulatory scheme for Indian gaming. The success of some tribal bingo operations cast gaming as one of the very few viable avenues for reservation economic development and job creation. In Florida, for example, the Seminole Tribe's bingo hall had already slashed reservation unemployment from 60% to less than 20%, and improvements in the quality of life on the reservation were apparent in upgraded housing and increased high school graduation rates. Congress's endorsement of tribal bingo as a proven and well-regulated tool of economic development is reflected in IGRA's categorization of gaming. IGRA regulates only two classes of gaming: Class 2, bingo and similar games, and Class 3, casino-style gaming, under two separate regulatory schemes that are similar in some respects and very different in others. By 1988, tribes had almost a decade of tribal experience and relatively few problems in regulating bingo. Casino-style gaming, on the other hand, was seen by Congress as more problematic. Thus, Class 3 gaming required a tribal state compact, giving the state the ability to negotiate state control over the Class 3 gaming. Class 2 gaming, on the other hand, fell under tribal and federal jurisdiction. The state had no formal regulatory role. Congress acknowledged in IGRA that following the Supreme Court's decision in Cabazon, Class 2 gaming clearly fell within tribal jurisdiction. If, as the court held, a public law 280 state such as California could not regulate tribal gaming, then no state had such power under federal law. So in IGRA, Section 2710A2 states that any Class 2 gaming on Indian lands shall continue to be within the jurisdiction of the Indian tribes, but shall be subject to the provisions of IGRA. In addition to the prerequisites that gaming may be conducted only by an Indian tribe and only on Indian lands within the tribe's jurisdiction, subsection B1 contains two further requirements that the Commission is well aware of. An Indian tribe may engage in Class 2 gaming on Indian lands if such gaming is located within a state that permits such gaming, and if the tribe adopts an ordinance that is approved by the NIGC chair. The permits such gaming requirement, for the most part, is easily met in the context of Class 2, as nearly all states permit charitable bingo. And the statute also requires that a tribal government exercise its political authority to enact legislation authorizing Class 2 gaming, and the subsection B2 further describes the content of the required tribal ordinance. This reflects IGRA's assignment of regulatory jurisdiction over Class 2 gaming primarily to tribes with some limited federal oversight and without any delegated authority to states. As the Senate report explains, that section stipulates that Class II gaming remains within tribal jurisdiction but is subject to IGRA. Although seemingly eclipsed by the more lucrative and expanding Class III market, Class II gaming remains important for at least two reasons. First, as the Commission is aware, tribes may operate Class II games in states that do not allow or refuse to negotiate casino-style gaming. Today, nearly every state permits bingo, opening the door to Class II gaming in those states. Even in states that allow casino-style gaming, a tribe may use Class II gaming to increase, for example, the number of gaming machines allowed under a Class III compact. Additionally, Class II gaming has become increasingly important and increasingly controversial because it has inspired technological enhancement and innovation that greatly enhances the profitability of Class II gaming and therefore its impact on tribal economic development. I'd like to now turn to IGRA's definition of Class II games. As IGRA puts forth, Class II gaming means the game of chance commonly known as bingo, whether or not electronic, computer, or other technologic aids are used in connection therewith, as well as, if played in the same location, other games similar to bingo. Class II gaming, of course, does not include, under the statutory definition, electronic facsimiles of any game of chance or slot machines of any kind. IGRA's legislative history reflects a similarly straightforward approach to the definition of Class II gaming. I'd like to quote, if I might, a little bit from the Senate report just to remind us of the language that the report uses. The report states that, consistent with tribal rights that were recognized and affirmed in the Cabazon decision, the committee intends in the definition section that tribes have maximum flexibility, as Frank indicated, to utilize games such as bingo for tribal economic development. The committee specifically rejects any inference that tribes should restrict Class II games to existing game sizes, levels of participation, or current technology. The committee intends that tribes be given the opportunity to take advantage of modern methods of conducting Class II games, and the language regarding technology is designed to provide maximum flexibility. Thus, Congress included IGRA's Class II technologic aid provision to ensure that tribes have that maximum flexibility to utilize bingo for tribal economic development. As the Senate report indicates, Congress did not intend to limit tribes to the technology as it existed in 1988, instead stating that tribes should take advantage of modern methods of conducting these games. At the same time, though, of course, IGRA's definition of Class II gaming expressly excludes electronic facsimiles or slot machines of any kind. The balance struck between a technologic aid and an electronic facsimile in the Senate report was that permissible technologic aids do not change the fundamental characteristics of the bingo game and are distinct from electronic facsimiles in which a single participant plays a game with or against a machine rather than with or against other players. That line between a technologic aid and an electronic facsimile soon was challenged. The statute, of course, does not define either term, and until it amended its regulations in 2002, the federal regulations promulgated by the NIGC offered only limited guidance in this regard. Initially, the federal courts followed a plain language approach that was guided both by the statutory language and the legislative history, holding that self-contained bingo or other Class II games in which a single player played against a machine rather than against other players were electronic facsimiles. For example, in Spokane Indian Tribe v. U.S., one of the first cases to apply this distinction, the Ninth Circuit held that a video lottery game, Pick 6 Lotto, was a Class III facsimile. The court readily concluded, based on the fact that the entire game was computerized and in the machine, that Pick 6 is an electronic facsimile in which a single participant plays against the machine. In another case, U.S. versus 103 electronic gambling devices, the Ninth Circuit considered Megamania machines, video terminals at which players competed in a linked live bingo game, and concluded that those were technologic aids to playing bingo instead of electronic facsimiles of the game. The court distinguished Megamania from the kind of pull tabs machine that was at issue in the Spokane case, on the basis that the Megamania machine was not self-contained with a single player, nor was it a facsimile. Instead, the machine squarely satisfied Congress's intent to allow technologic aids that broaden potential participation levels in Class II games. This early set of cases, spanning from 1992 to 2000, developed a relatively consistent and increasingly coherent approach to the statutory language and to Congress's intent, as reflected in the Senate report. In 2002, the NIGC amended its regulations defining technologic aids and electronic facsimiles, and these amendments tracked the guidance provided by the case law. 2 federal appellate courts have applied those amended version of the NIGC's regulations, both reaching predictable conclusions in line with the prior body of case law. In U.S. versus Santee Sioux Tribe, dealing with the Lucky Tab 2 machines, the 8th Circuit held that the machine was a Class II technologic aid. It was a pull tab dispenser and reader, which was one of the examples given in the NIGC regulations of a permissible technologic aid. And in Seneca Cayuga Tribe versus NIGC, which dealt with the magical Irish instant bingo dispenser system, another pull tabs machine, the court reached the same conclusion, that it was a Class II technologic aid. The government in that case argued that because the machine did not broaden participation in the game of pull tabs, it could not qualify as a technologic aid. But the court reasoned that the NIGC definition, along with the prior case law, did not require that an aid broaden participation, but merely identified that broadening participation was a factor favoring finding that the machine was a Class II aid. Despite the increasingly clear directives of federal regulatory and case law, a conflict between the NIGC and the U.S. Department of Justice fueled legal and political contestation over Class II machines. In both cases, the Santee Sioux Tribe and Seneca Cayuga Tribe, the U.S. Department of Justice took a position that was contrary to the NIGC, contending that both games at issue were Class III electronic facsimiles, or alternatively, even if they were Class II technologic aids, the games violated the federal Johnson Act's criminal prohibitions against gambling devices. The government sought review of both decisions, supported by a number of states as amici, but the U.S. Supreme Court denied cert on both. Additionally, as Class II technology continued to enhance the games by enticing players with slot machine-like displays, state and federal officials became increasingly concerned about the regulation of so-called bingo slots. Bingo aids have rapidly evolved from the electronic bingo cards that are often used on cruise ships to consoles with spinning video reels that resemble, at least superficially, slot machines. While the box or the console looks like a slot machine, the game played on the machine, as you well know, is, of course, an external bingo game, rather than the individual random number generator of a true slot machine. Beginning in 2004, the NIGC sought to develop new regulations with definitive classification and technical standards for distinguishing Class II aids from Class III facsimiles. As the NIGC explained, the Commission thought that this was important because of the accelerating changes in gaming technology, as the Commission put it, and methods threatened to obscure the distinction between Class II and Class III gaming under IGRA. 5 years later, subject to intense political pressure from both sides, the NIGC has not been successful in promulgating new regulations. On one side, critics charge that the bingo slots raise the same regulatory concerns of slot machines, regardless of the actual game being played. I have criticized this as something that I call duck logic. If it looks like a slot and it plays like a slot, it must be a slot, even if the actual game being played is bingo rather than a true slot machine's random number generator. On the other side, tribes and games manufacturers argue that the current state of the law is sufficient to distinguish between technologic aids and electronic facsimiles, and that efforts to constrain Class II technology are meant to increase state control over tribal gaming and will negatively impact tribal economic development. Indeed, an independent economic study commissioned by the NIGC estimated that the proposed regulations would cost tribes more than $1 billion in lost revenue. And in June 2008, the NIGC withdrew the revised set of proposed classification regulations. To end my testimony today, I'd like to cover 3 points to offer some guidance for tribal governments in their own regulation of Class II gaming. With my co-director, Dr. Light, I have argued elsewhere that the regulation of Class II machines should be guided not by the appearance of the console or the box of the game, but by Indian gaming's overarching policy goals. Current debate over the alleged blurring of the line between Class II and Class III machines due to technological innovation is problematically and artificially divorced from the policy goals of Indian gaming. Though our prior arguments have been directed at federal regulation, the same goals should hold true for tribal regulation of Class II gaming. The first goal should be to provide for effective regulation. Indian gaming, including Class II gaming, of course, must be effectively regulated. And the two key functions of gambling regulation generally are to ensure fair and honest play and to protect the proceeds. There is no clear indication that the current regulation of Class II machines, even those that look like slot machines, is not capable of ensuring fair play and protecting tribal revenue. Tribes, with the guidance of current federal regulatory and case law, appear by all accounts to be capable of effectively regulating Class II machines. One oft-cited concern is that bingo slots, like slot machines, carry a higher risk of problem and pathological gaming, that the speed and the excitement of the play has the potential to entice gamblers to lose more money than they can afford, triggering the negative effects of problem gambling. Though this may be a real socioeconomic impact of Class II machines, it must be weighed in the context of other socioeconomic impacts, both positive and negative. Thus, given the study noted above, as well as the potential for states to wield greater political and legal control over tribal gaming through increased regulation rather than speculation, calls for bright line regulation at the federal level should be supported by factual findings rather than speculation to support the need for any additional federal or state regulation. At the same time, though, tribal regulation and tribal initiatives should err on the side of minimizing problem and pathological gaming, as many tribes already actively do. Indian gaming, of course, is public gaming. It is conducted by tribal governments, and it is driven by the public interest, not by profits. Tribes are uniquely situated and perhaps uniquely obligated to regulate gaming in a way that best serves the public interest. The second goal of tribal regulation should be to facilitate tribal institution building. One of the largely unrecognized successes of Indian gaming, at least outside of Indian country, is the role that it has played in tribal government institution building. And certainly we heard much of that from the last panel. Class II gaming helps tribes to build effective and responsive government institutions in a number of ways. First, Class II gaming allows tribes to build, manage, and regulate sophisticated gaming enterprises. Second, because no tribal state compact is required, Class 2 gaming allows tribes to make decisions free of state politics about effective regulation, appropriate use of revenue, appropriate economic development and growth, or other exercises of sovereign authority, including the preservation of cultural traditions or tribal norms. Third, Class 2 gaming allows tribes an opportunity to demonstrate effective governance, such as through holding an historic and landmark regulatory hearing on Class 2 gaming, as we are privileged to witness today, which can be very important in terms of the respect that tribal governments are afforded by state and federal officials, agencies, and policymaking or legislative bodies. And fourth, Class 2 gaming provides an avenue for tribes to raise revenue to underwrite or extend tribal government functionality and responsiveness, even when Class 3 gaming is unavailable or is constrained by state law and state politics. And finally, the third goal of tribal regulation should be to catalyze the mutual respect and government-to-government negotiations and relations. Certainly at the federal level, reforms in tribal gaming regulation should stem from government-to-government negotiations and ought to facilitate rather than undermine government-to-government relations. On the tribal side, gaming regulation is a highly visible exercise of governmental authority. Tribes, like states, can serve as laboratories of public policy innovation. Tribal governments have been and should continue to be leaders in effective and responsible gaming regulation, experimenting with carefully considered approaches to minimize gaming's negative socioeconomic impacts while maximizing its positive impacts. Again, I thank the Commission for the opportunity to appear before you today at this important and timely hearing, and I'd be glad to answer any questions you might have.
Thank you, Dean Rand. We have set aside an hour for discussion and questions. Mr. Foreman, do you have any questions of this panel?
I do. Thank you, Madam Chairman. First of all, I don't know how many of the people in this room or outside of this room know the real story of the Cabazon case and how Mr. Ducheneau and others, both congressional staff and tribal legislative advocates and attorneys, managed to, on the one hand, use the legislative process to influence the outcome of the judicial process, Supreme Court, creating legislative history in 1985, 1986, which found its way into the committee report on S-555, and on the other hand, to use the judicial process to affect the outcome of the legislative process. It stands today, in my mind, as a paramount illustration of how and why litigation alone often has proven inadequate to protect and advance tribal interests. I was one of the lawyers who litigated the Cabazon case. My associates worked with Mr. Ducheneau and his colleagues as they worked their legislative magic, and I'd like to express my personal and somewhat overdue thanks to Mr. Ducheneau for those efforts. Looking back, I don't know that any of us thought in 1985, 1986, 1987, 1988 that we would be sitting in a place like this today, having come as far as we have. But it's been quite a ride, and again, thank you so much. I do have a few questions, and these are questions that are equally to the members of the panel, but you can choose amongst yourselves who to answer, because I suspect your answers will be the same. But for the record, I would like to get your opinion on whether you feel there is a legal basis for Chairman Hogan's contention that a computerized bingo system that allows multiple players to participate in a common bingo game by pushing a button only once is a Class 2 game. Is a Class 3 game.
We've talked about this today, and I mentioned in my comments, George, that bingo is defined in the Act. Courts have recognized that. Bingo is what IGRA says it is, not what Phil Hogan says it is. There's nothing in IGRA which says that bingo as a Class II activity ceases to be that based upon the time it takes to play a game. So that if a game can be completed, one game can be completed in a day, as long as the essential characteristics of bingo are maintained under the definition, it's a game of bingo. If you shorten it to an hour, it's a game of bingo. If you shorten it to 20 seconds, or a second, or a millisecond, if it maintains the essential characteristics of bingo as defined in IGRA, it's a Class II operation. What is the difference legally between 3 touches and 2 touches and 1 touch in terms of converting an activity from as IGRA defines them, a Class II operation to a Class III operation? What's the legal basis for that? Put that up against what the professor has just said here and I have said about our intent in IGRA, set out in the committee report, that the tribes would have the maximum flexibility to use advancing technology to enhance Class II gaming for their customers. If that technology can have you play the game of bingo with other people, hundreds, maybe thousands, in a second by using 1 touch, I don't see the legal basis upon which Phil and others say that somehow converts it to a Class III. I don't see a legal basis for it.
I certainly share that view. I might add an additional policy consideration of what is the purpose of the distinct regulatory schemes for Class II and Class III gaming. Is it that a Class III slot machine only needs to be touched once, while bingo has multiple touches? It seems to me that that was not what Congress had in mind in deciding that these 2 machines needed different regulatory schemes. Instead, it seemed to stem from both the fact of tribal experience with bingo and the different nature of the games. That bingo is a game, however it is played, that's played with other people rather than against the random number generator of the slot machine. That seems to have not much, if anything, to do with how many times a button is touched.
In your collective opinion, and most specifically, I guess, Mr. Ducheneau, when Congress was considering IGRA, was there any thought given to whether a player has to be able to sleep a bingo in order for an electronic version of the game to be Class II?
I didn't know. I had never heard that term during the consideration of IGRA. I didn't know what sleeping a bingo was. No, I mean, there was no consideration, there was no discussion, no document which indicates that a player had to be able to sleep a bingo. We didn't even know what it was.
In the definition of bingo, there are references to games similar to bingo and in particular reference to something called instant bingo. First of all, what did Congress have in mind when it used that term? And second, can you think of a rationale to harmonize the use of that term with the NIGC's apparent belief that an electronic system cannot be instant?
Cannot be, excuse me.
Instant.
Instant. I, in fact, had gone down to Florida to visit the Seminole operation there prior to enactment of IGRA. And they were playing about 3 different kinds of games, as I recall. Some of them were more or less the traditional, even though technologically enhanced, by the technology of that day, more or less bingo as we know it. But there was I think there was an instant bingo, and there was another kind of game that play there that was bingo-like. So I at least was familiar that the old Catholic Church basement bingo had moved on from my day, and that there were other ways of playing it, other kinds of processes. So when we came up with a definition of bingo, we were familiar with these other kinds of innovative uses, and if they could not be called bingo, they were bingo-like. You know, they used some of the same kind. They were games played by people against each other, and they used different kinds of formats. And they, you know, if you could not say they were bingo, they were bingo-like. I have to be honest with you, George, to say that I'm not quite sure what we meant and what it means, but it was an attempt to be, on our part, I think, to be as inclusive as we could with respect to making Class 2 available to the tribes.
Thank you. IGRA, this is going a little bit beyond the realm of Class 2, but relevant since Class 2 has a role in compact negotiation. IGRA obligates a state to negotiate in good faith, but it doesn't define good faith. Based on your experience in the drafting of what became IGRA, what did Congress mean by good faith in compact negotiation?
You know, George, we borrowed that phrase from labor law, and I'm far from an expert on labor law. I was familiar that the NLRB and the courts had occasion, on many occasions, in which to look at negotiations ongoing between unions and management over a new contract, and they were able to make findings based upon some broader kind of legal obligations to say that one party was not really bargaining in good faith. Let's take an example that occurred in Wisconsin soon after the enactment of IGRA, where the tribes approached the state of Wisconsin for a compact. And the state said, okay, we'll give you a compact if you agree to compromise some of your treaty hunting and fishing rights. Okay, now that very clearly is not good faith bargaining over a gaming compact. If a state said, well, you know, we want to play a role in the regulation of Class 3, and we think that we ought to be able to have regulatory power in this area of your Class 3 gaming. Well, that's kind of what we expected to go on, a back and forth over how Class 3 gaming was being offered in the state by the tribes, and what role the states would play, and they could say, well, we insist that you guys pay for our costs of background checks. I don't think the court would say that was bad faith bargaining. I think it would be a legitimate kind of thing, but we didn't. In one case, we did. I think maybe I mentioned it. In one case, we actually said that an attempt by the state to tax the revenue would be ipso facto bad faith. But no, I don't think we went through a whole list of things and said this would be bad faith, that would be good faith. It was a word of art in the labor law.
What was it? Did you want to add something, Dean?
If I might,
Yeah.
one logical place to look in the statute for some guidance is the provision that lists the kinds of provisions that could be included in a tribal state compact. By extension, it might mean that those are the only things that are appropriately negotiated, and that trying to negotiate things outside of those subjects might be bad faith. Additionally, I just note that one of the unfortunate effects of the Supreme Court's decision in the Seminole Tribe case is that it froze the case law on what good faith is or what bad faith is, so that we haven't had the chance for the federal courts to further develop that statutory term and provide further guidance for both tribes and states.
Well, one thing you might want to look at is the Salish Kootenai testimony here today, and it is true of other tribes where the state has insisted upon an arbitrary limit on the number of machines, rather than saying economy, the economics of the thing will drive how many machines a tribe can have, saying, well, you can't have more than 150 machines or 200 machines or 500 machines. That to me a court could say is arbitrary and not in good faith.
Did the Congress contemplate that good faith negotiations inevitably would result in an agreement? Or did it contemplate that after good faith negotiations, the state could say, I'm sorry, we're just not going to, we can't agree to this, we can't agree to that, and essentially take a position on one or more of the subjects that are appropriate subjects of negotiation and simply not agree to the tribe's position and still be able to say, well, we negotiated and we think the state's interests require this, therefore, if the tribe doesn't accept our terms, there's no agreement, but we acted in good faith. Was that an anticipated outcome?
I think probably. I think, Jenny Boylan is here, she could help me out on this, but I think we anticipated that states would become intransigent on agreeing to a compact. And depending upon what a tribal demand was in a compact, if a tribe would insist upon a certain provision which was wholly unreasonable and bad faith, and the state said, we simply cannot accept that, we can't even negotiate it, I think a court might say, we won't find that the state has to agree to that kind of thing, but I think we understood that there would be, this was prior to Seminole, I think we understood there would be cases clearly where the states would insist upon things which a court could reasonably say was not in good faith, and say that the failure of the state to go forward with these negotiations based upon that demand is in and of itself bad faith bargaining.
Did the Congress think about the application of a good faith standard to negotiations to amend an existing compact prior to its expiration? Was that ever part of the thinking? What if you had a compact in place, been approved, working well, has a provision for renegotiation, and the state comes back and tries to get in renegotiation what it didn't get or even ask for in the initial negotiation?
I don't have a good answer for that, but I think that what I would suggest is that the state's good faith obligation would logically extend to compact renegotiations as well. I think that the additional legal guidance might come from the terms of the original compact itself. Under what circumstances did the parties agree would be appropriate to renegotiate? And it might be the difference between a compact that has no language indicating that there would ever be a time to renegotiate, and another one that indicates that every 5 years, at the request of one party or another, renegotiation would be appropriate. So I'd say that those two things would be relevant in that.
And I have to be very candid, George, to say to you that I don't remember thinking about a compact of a certain term and the need to renegotiate when we agreed to the compact provision. But I would agree with the professor's comment that had we thought about it, it would have been that any renegotiation would be done under the same kinds of general terms of good faith negotiation. But I never really thought about it.
Thank you very much.
Mr. Belanger, would you please continue the panel questions?
Sure. Michael, why don't you go first? Go ahead.
I'll never get this chance again. I stand in awe of both of you. I'll let you know that right from the beginning. And I want to ask two different types of questions because I'll never get to ask you these questions again. The first thing I'd like to do is go back and take another bite at the bingo apple of sin that George Foreman queried you about a moment ago. I have 36 years in operating charity bingos and Indian bingos, and I know what a sleeper bingo is. I've had a 300-pound woman pulled off of me who woke up to discover that she had missed a $10,000 jackpot, and I was the one who had the unfortunate responsibility of telling her that. So sleeping bingos is a reality that our bingo managers live with. And I like the term, Catherine, that you use, a duck logic. So the chief counsel to the National Indian Gaming Commission, who I think practices duck logic, is the one that has promulgated the concept that George Foreman was just elucidating, that actually is the underpinning. I think, not being a lawyer, I do think it is the legal underpinning of the argument that swirls around the one-touch, two-touch controversy. So I want to hoist that balloon up again and give both of you another opportunity to take a shot at it, because I think it would be most helpful to the commission as they try to think through this difficult question. And I'll go with you first, Catherine, and then to Mr. Ducheneau. The statutory criteria of what constitutes a game of bingo, correct me if I'm wrong, does include the game of chance known as bingo, played for prizes, in which the first person covering a pre-designated pattern using numbers or symbols wins the prize. The Chief Counsel for the National Indian Gaming Commission has opined numerous times in many forums that an intrinsic characteristic of the game of bingo is that somebody must enroll in the game, or either having a piece of paper or some other element, usually a ticket to demonstrate that they paid for the piece of paper so we can verify they're entitled to a prize and didn't somehow sneak in. And that in addition to being enrolled in the game, participating in the game, that they must do something demonstrative to notify the caller that they have to stop the game in order to claim the prize. Now, George threw up the answer, which is obviously instant games and pool tabs that do not require that behavior, games similar to bingo. But if you were counseling this commission and they were attempting to make that determination and to think through those on the dark side here that would use that argument, what would you counsel our commission and how to think about that problem?
I think that, of course, as the federal courts have pointed out, that for purposes of IGRA, bingo has the three components that are set out in the statutory language. I believe that the Ninth Circuit case, the 103 machines case, also address the issue of whether the corner mania game that went on during the bingo game was in line with the statutory requirements. And the court held that it was, that the fact that folks could win the corner mania games multiple times during the course of the bingo game didn't remove it. And in any event, it would certainly qualify as an other game similar to bingo. So I think that both of those would address the issue that you've raised. I might offer, too, that as we talked about the Commission's contention that there is a need for a brighter line, that the line is getting blurred, it should be relevant that in 2009, many tribes have a decade or 2 decades of experience with successful regulation of Class 3 gaming, including slot machines. So the point I'd like to make with that is that perhaps a neon bright line is not as critical as Congress may have thought in 1988.
Let me address a little facetiously the first part of your comments. I think that robotic technology exists today that you could construct a robot that looked very much like a duck, walked very much like a duck, and quacked very much like a duck. But despite what Penny and Phil would say, that's not a duck.
That was a great answer. The robot.
And on one touch, two touch, I agree. I mean,
That was,
we've talked about that already, and it's not an essential part of bingo, as IGRA defines it.
thank you for those thoughtful answers. And before I ask the second question, is the idea that, then it was promulgated by Ms. Coleman, I believe, that one corner or two corners did not constitute a pattern, flew in the face of the fact that for most Indian tribes, at Morongo, as an example, in 1989, the Morongo band was able to offer 18 $1,000 games utilizing a 15-up paper pack, which meant we bought 15 pieces of paper, but we were able to play 18 games on it. The last game, one of the staples of the Indian gaming industry was the progressive, 4 corners, picture frame, blackout. And that's an example of where their logic flew directly in the face of the reality of how bingo was actually practiced in Indian country. My last question to Ms. Rand, in your excellent book on Indian gaming and tribal sovereignty, you develop a very thoughtful and interesting methodology for evaluating the importance of Indian gaming to Indian tribal governments with your interior, exterior viewpoints. And I first read that idea in, I think in the Whittier Law Review, where you first wrote that first article. And it's my opinion that most of the media and politicians and critics of Indian gaming are smitten with the amount of money that some Indian tribes are making and have failed to recognize that one of the stated purposes of the Indian Gaming Regulatory Act that Frank put in there was to build strong tribal governments. I would really, you sit before you a living, breathing example of the actualization of that government policy today. Could both of you just talk for a minute about the role of Indian gaming in helping to revive and build and put muscle on our tribal governments?
I'd be glad to start. Obviously, the statutory language of IGRA indicates that Congress's goal was to facilitate tribal economic development, tribal self-sufficiency, and strong tribal governments. In the last couple of years, Senator McCain has indicated that he feels that there's a need to revisit IGRA and to revisit Indian gaming regulation, not because of concrete or proven problems with the regulatory scheme, but simply because of how the industry has grown, particularly how the revenues of the industry has grown, and perhaps because of the number and type of venues that have sprung up. I think that IGRA's public policy goals remain as pertinent and as needed today as they were in 1988. It seems to me that that is one of the sole constants that we can take from the legislative history, is that the intent of Indian gaming, both by Congress and by the tribes themselves, is to strengthen tribal governments for the betterment of tribal communities across the nation. One of the things that Dr. Light and I have talked about is what we believe the legacies of Indian gaming should be. And certainly we can't expect that in 20 years these legacies will be fulfilled, which is critical for the continuing of the federal and state and tribal support of Indian gaming. But one of those legacies is that all tribes across the nation have strong, well-functioning tribal governments that are able to respond to tribal members' needs and are responsive to the concerns of tribal members. I think that that along with things like diversified and strong and healthy tribal economies and strong and healthy tribal communities, that will tell us when IGRA has achieved what it needs to achieve. The focus on revenue is misleading and is fueling a controversy that should not exist.
I'm glad she brought up McCain's name. I worked with John in the House and the Senate on the gaming legislation. And I had considered him during that time to be generally well-disposed toward tribes and tribal sovereignty and the right of tribal self-government and the needs of tribes. After he'd become chairman of the Indian Affairs Committee, I followed his activities from afar. And at one point, he was reported in the press as saying, if we had known that Indian gaming would be this big, we might have done something differently. And I thought, does he mean that if we had known the tribes were going to be so successful, we would have put economic limits on them? That we would have said that they can't grow beyond a certain annual revenue? Or would we have done that, John? Would we have imposed those kinds of limitations on Indian tribes that are not imposed upon non-Indian economic activities? It was just, I was just astonished that. I have to say that I've always thought that I come from a long tribal sovereignty background. I grew up involved in politics all my life, and I'm very sensitive about tribal sovereignty. And to some extent, I think Indian gaming became a double-edged sword. And is, to some extent, a double-edged sword for Indian tribes and Indian people. In some respects, the success that John decried has been debilitating to some of our people. But on balance, I think Indian gaming has achieved the goals that we were thinking about when we did IGRA in terms of strong tribal governments. Look around you. Here in California, the tribes went up against some very powerful political forces and beat them. Indian tribes are now political players in the political scene in many states. John Tester of Montana owes his seat to Indian tribes and Indian voters, and a lot of that is based upon the activities of Indian tribes in gaming. It's been said here today by witnesses, and I'm sure the same is true with the Sycuan tribe. Indian gaming activities are providing jobs not only for their own members, but for the surrounding community and having a positive impact on the economies. There are just so many positives for Indian tribes growing out of gaming that the few very serious negatives, I think, are outweighed.
All right, Michael, thank you. I have several questions, but rather than take up a lot of time, I have one that's been on my mind, and with, again, as Michael said, with the two of you in front of us here, I'd like to see if this tortured logic makes any sense to you. And I'll confess it's not my logic. It actually is something I recently read that Chairman Hogan's written. But it concerns me because it's an argument that I really hadn't seen before and hadn't seen begin to be played out until I began to spend more time in California. And it's about the relationship of gaming devices as defined in a Class 3 compact to limitations that those definitions may impose on Class 2 devices. I'll try to say it again. That given the premise that Class 2 is Class 2 and the things that we've been talking about, that through the process of compact negotiation, that how Class 3 gaming devices are defined may in fact necessarily or arbitrarily place a limit on what is or isn't a Class 2 device. We're seeing that begin to be played out here to the extent that the CGCC, for example, is contending that a device that's a one-touch device is actually, should be a compacted device. So that's maybe the manifestation of the argument. But I'm wondering what you think about the validity of that argument or not, or where that argument may take us if we follow that path.
I think that I understand you to say that if a machine qualifies as a Class 3 device under the compact's definition, then it should be a Class 3 device regardless of IGRA statutory definitions in the legislative history.
Yes.
I think that's completely wrong. I think that IGRA was intended as an overarching regulatory framework, and that in order for a tribal state compact to be valid, it has to comply with IGRA's provisions. So something in the compact that was contrary to IGRA's provisions should not stand. It should be trumped by IGRA itself.
I'm not going to disagree with that, but I would go on to say that even assuming that Catherine is wrong in her analysis, is what Phil is suggesting that if some foolish tribe agreed to such a provision in its compact, that it would be binding upon all other tribes, that now that because this tribe agreed to this silly provision in their compact, that this particular machine, which is really a Class 2, will be treated as a Class 3, changes the law? Is that
I'm not sure how far he wants to take the argument, but I think it manifests itself in particular here in the example that I use, that a one-touch device, by his reckoning, is a Class 3 device, and therefore should be subject to the compact in California, for example, a compact between, for example, Sycuan and the state of California, just because it happens to be under his definition a Class 3.
And the California Gambling Control Commission, citing his letter to Metlakatla, says that these should be counted as compact devices because the NIGC says they're Class 3.
Is there I hate to ask the commission panel, is there a compact that you're aware of which provides that the tribe and the state have agreed to in any state, that provides that a one-touch bingo machine is a Class 3 machine? Are we aware of any?
I'm not aware of any.
Nor am I. And that's one of the things that triggered this proceeding, quite frankly.
Yeah, I mean, you know, I was contacted by someone about an Alabama situation where a non-Indian proposed operator wants to offer one-touch class, or I think it's one-touch, Class 3 or Class 2 bingo machines as Class 2, and the state is saying, no, they're not, and they're citing Phil Hogan as their source. I mean, is their authority. And I understand the same is true here, that the state of California is saying, well, Phil Hogan says it's one touch, therefore it must be. That's ridiculous.
Well, I don't disagree with you, but I wanted to lay out what I believe is the logic of Chairman Hogan. I read it in an article a couple of months ago, and at first I sat back and thought, well, that's an interesting way to look at it. And I share your conclusions, but I wanted to ask the question here.
I'm not sure that it's pertinent, but as I sit here and process it a little bit more, it certainly seems to me that since the Secretary is required in approving a tribal state compact to ensure that it does not violate any of IGRA's provisions, that a compact should be read in conformance with IGRA, not vice versa. That it would be the cart leading the horse to decide that the compact's definitions are what should guide the classification, which should be controlled by IGRA rather than the compact.
Right, it's interesting. I made notes about the role of DOI and the compact provisions, partly because Frank brought up the fact that they're not really reviewing the revenue sharing very closely. And by putting it back into what is essentially a political realm when it's going for that kind of approval, I'm not sure you're going to get that careful analysis every time, but that's my opinion.
I think that's a good example, Joe, is that, you know, you have many compacts out there where the state has imposed taxes on tribal gaming revenue in violation of IGRA. And the fact that those provisions are in compacts approved by the Secretary of the Interior doesn't amend IGRA. I mean, IGRA still says what it says.
Absolutely agree with you. Well, then, just one more question along those lines, separate and apart from that in that funny argument I just presented to you. You brought up the ordinance approval and how important the ordinance is to both the self-governance of the tribe and the regulatory body that administers it. And in the context of reviewing a compact, Professor Ann, you said, well, there's certain provisions, or when you're dealing with good faith or bad faith, there's certain items listed in IGRA that should be the guidepost. And up until recently, up until the Metaketlas situation, there's been a pretty strict adherence to the items required for an approval of a gaming ordinance. And then in the Metaketla decision or the situation, the tribe decided to put, for a variety of reasons that we don't need to get all into here at this point anyway, a provision for a one-touch. And Phil disapproved the ordinance based on that basis alone, or the current chairman disapproved the ordinance on that basis alone. I'm curious your view based on history and your experience, that given that up until that point it's been convention that the only items that the chairman reviews are those that are laid out in the statute. Does he or she have the authority to disapprove an ordinance when there's something tacked onto it or require an amendment? What sort of precedent, if any, does that activity or does the Metaketla situation present?
Let me address part of it, but leave the rest of it to the hard part to Liz. If you go back to the first bill we introduced in 1983, H.R. 4566, through the next 6 years, you will see that the tribal gaming ordinance requirements, first there were 5, later 6 specific requirements that had to be in the ordinance. And you will see that we did so on the basis that if the gaming ordinance minimally met those 6 standards, minimally, approval by the secretary at that time was to be almost administrative, with little discretion involved. So I don't want to get into the, I just want to make that clear, is that even today, the chairman's authority to approve or disapprove a tribal gaming ordinance should still be premised on the basis that if the ordinance minimally met those standards, he had to approve it. I don't know whether that's ever been tested or not. In terms of the in terms of extraneous matters beyond those 6 things being included in a proposed gaming ordinance, I'll let her do that.
IGRA's requirement that the NIGC chair has to approve the tribe's gaming ordinances is clearly an example of that relatively limited federal oversight over Class 2 gaming, and is also an imposition on tribal sovereignty. I think that with that in mind, the statute is appropriately read as not an expansive power of the chair. The power to pass the gaming ordinance arises out of inherent and internal tribal sovereignty. IGRA doesn't give tribal governments this ability. Tribal governments have this ability, and IGRA is placing a limitation on it. I think for that reason that the limitation should be read narrowly, and it seems to me appropriate that disapproval of the tribal gaming ordinance should be limited to failure to comply with the statutory requirements and not anything else.
Let me just go a little bit beyond that, and I'm sure George would appreciate this. Yes. There's the rule of construction in Indian law about ambiguities being construed in favor of the tribe, in favor of the Indian. If you look at the legislative history of IGRA, we tried to be very careful on both sides of the hill, on the Senate and the House, in writing reports and writing floor statements for our principals. In any way we could, we tried to be very clear that we intended IGRA to be construed according to that rule of construction. That if there were any ambiguities in the language which would cut against the tribe and fulfill it was to be construed in favor of the tribe. And the commission has ignored that routinely and had perverted it in one case. So I think whatever the specific response may be to the Metlakatla thing, clearly that was our intent with respect to interpretation.
All right, Madam Chair, I think we're coming up close to the timeline, so if so, I would suggest that I'd like to ask one more question, and then maybe we break for a few minutes and come back, and I know there's questions.
Okay.
Just one more question, and it's a broad question, and it's one that's been on my mind since my time at the commission, actually before my time at the commission, and it's a broad question. It's about the intention or the applicability of due process within the processes of the commission. For example, on ordinance review, on gaming, anything that requires a chairman's approval, what level of due process was intended as opposed to the level of due process that's actually that has been administered to this point?
I'm not familiar in detail with some of the versions that go on in the commission that to be able to comment intelligently on that. Now, in terms of what level of due process, I don't know that there's a level of it that...
Well, I think that's
Yeah.
right.
Did you?
I think that the best answer that I could offer is that the NIGC is not the only federal agency, and there are a number of federal laws that govern federal agencies and how they conduct hearings and promulgate regulations and so forth. So I certainly think that in terms of IGRA, the Administrative Procedures Act, and other federal law, that the NIGC certainly should be held to at least that. The additional piece that may apply to the NIGC in a way that it may not apply to other federal regulatory agencies is the obligation for government-to-government negotiation and government-to-government relations, and the respect for tribal sovereignty that's due in this particular context.
And maybe we should have done it explicitly, and we didn't. But what the commission has done under various administrations is basically put the burden of proof on the tribes. In my mind, in some of these areas, they shifted, or if they have put it over the burden of proving a thing on the tribe, and I don't think we intended that the tribes be put in that position. That if the commission had a particular grievance with the tribe, that they had to prove it. Not that the tribe had to prove that it didn't exist. And that's something I think if there's a lack of due process in the commission, I think is clearly, in my mind, that they have put the burden of proof on almost all their disputes on the tribe.
Chairman, how do you...
Oh, at this time, we'll take a 10-minute recess, and then we'll continue this discussion.